While I'll introduce the four topics, wage and hour enforcement issues, some enforcement issues regarding OSHA, or Occupational Self and Health Act, workers' compensation, and I want to talk about one particular piece of workers' compensation, and that is the problems that arise when you have an undocumented worker that applies for workers' compensation. And then the E-Verify program and I-9 compliance. The U.S. Chamber of Commerce just sent out sort of an alert that they are very concerned about technical violations that are repeatedly occurring with employers and their requirements in filling out I-9 documentation. There are forms and there are instructions, and it's not all that hard. You don't ask for the wrong things and so forth, and you'll be okay. But we're seeing more and more I-9 technical enforcement actions that employers are paying for. So I'm going to go over a little bit of those issues. So first, wage and hour. What are the hot topics? Worker classification is very much on the front burner again. That is, are you an employee or an independent contractor? Do I give you a W-2 or do I give you a 1099? And federal and state governments are collecting their lost tax revenue by coming after folks who don't classify folks appropriately to try to avoid the tax. DOL has a new strategy in the Biden administration. It's called Plan, Prevent, Protect strategy, the 3 Ps. And it extends to worker classification enforcement. One of the things that they're talking about doing is requiring employers to provide workers with basic information about their employment, detailing exactly how their pay is calculated and why they're classified the way they're classified, whether they're exempt or non-exempt, those kind of things. So you have to provide detailed explanations of that. It's not just you know what, your salary, you're exempt, and here's how we're going to pay you. Employers that seek to exclude workers from FLSA coverage will be required to perform a classification analysis, disclose that analysis to the worker, and retain the analysis to give to wage and hour if they're asked. And also the DOL strategy addresses burdens of proof when employers fail to comply with the record-keeping requirements. As you may know, which, if you don't have records and the employee comes in and has a napkin that the employee has written their hours on, that napkin is going to be evidence in litigation. What's the practical impact of this worker classification enforcement plan? Well, the status of the particular worker is more than ever going to be a product of all the facts and circumstances of that worker. You may have heard of the IRS 20-factor test. Well, they're doing away with the 20-factor test, so no longer can you tick off that test and say, well, I've got 15 or 16 of them, so I think I'm okay. They're going to look at every relationship, every individual employee, every individual employment situation, and examine whether that person is properly W-2'd or 1099'd, whether that employee is paid overtime or whether that employee is entitled to overtime, all of those things. Okay, let me talk a little bit about workers' compensation. I told you this is going to be fast moving. One of the issues under workers' compensation over the last decade or so has been, what do we do with undocumented workers? Can they even apply for workers' compensation? Do I have to pay it if they do? And in 2002, there was a Supreme Court case called Hoffman Plastic versus the NLRB, which seemed to indicate that the answer might be no. In other words, undocumented workers cannot get workers' compensation benefits. That case was not a workers' compensation case. It had to do with back pay under the National Labor Relations Act, and the court opined that the worker had violated the Immigration Reform and Control Act by attempting to work without documentation, and therefore that employee was not entitled to back pay under the NLRA. So workers' compensation folks latched onto that and said, aha, we're going to stop paying workers' compensation benefits and disability benefits and the like. But many subsequent appellate courts, in fact all subsequent appellate courts except for the courts in Arizona, have determined that Hoffman's not to be read that way, and they have basically said that we're going to make a workers' compensation decision independent of the documentation status or the alien status of that worker. The only holdout is Arizona, and Virginia tried to do it the other way, but the legislature quickly jumped in and said, no, that's not the way we're going to do it. These folks need to get benefits if they get hurt on the job. despite this consensus and coverage, there are some issues with undocumented workers applying for workers' compensation benefits. One is, how do they prove the eligibility for disability payments? They have to prove they're unable to work, but if they're not documented, then they're unable to work technically under the law. And so there have been some issues with that. Most of the cases are coming out that we're going to determine that eligibility, again, independent of their right to work and their documentation to work. There's also an issue with disclosure of disability status and discovery. The fear is that the attorney on the other side is then going to ask for documentation of the right to work, and that could lead to deportation. So there's kind of a catch-22 there. And there are ethical questions for the lawyers. You know, do the lawyers take these cases and completely ignore the fact that they have a worker that has not properly documented their ability to work in the United States? So there are issues there. Again, I think I'm 8 minutes into this now. Let me fast forward to OSHA. There is sort of a new sheriff in town with regard to OSHA as well. There are significant ramp-up OSHA enforcement efforts. For example, employers will be required to implement an injury and illness prevention plan under the law. Employers are required to train employees in languages that they can understand, and most importantly, perhaps, is that violator enforcement program is going to significantly ramp up penalties, where you were seeing penalties like $500, $600, $1,000 for a significant and continuous violation. Now we're talking about $5,000, $10,000 violation penalties. So it's something that you want to make sure that your risk management people are paying attention to and taking care of. The last thing I want to talk about is, I was asked to talk about alien certification. I'm not an immigration lawyer, so about the best I can do is talk about immigration employment related matters. And one of those that comes up with us all of the time is, do I have to do E-Verify? How do I complete an I-9? Why am I in trouble with folks because my I-9s aren't retained and those kind of things? So I'm going to go over just some of the basic ground rules, and I'm happy to take questions on this. As the employer, you are responsible for completing Section 2 of the I-9 after you've given the form to the employee. In Section 2, we get a lot of questions about, well, you know, what kind of documents can I accept? It's right in the form, and it tells you the list of acceptable documents, tells you what you can accept, and it tells you that you can't demand a certain form of identification. If the employee indicates that they're only authorized to work for a specific period of time, you have to pay attention to that. You cannot let that lapse. That is not just the employee's problem. It becomes the employer's problem very quickly. As I said, you accept any documents that an employee offers from the list of acceptable documents. If they appear to be genuine, relate to the employee, you must review the original documents. You can't accept photocopies. You also have to maintain the forms. You have to maintain the records. I get this all the time. It's like, well, I don't know where that is. You know, you have to retain the forms for the time period that's required, 3 years after the employee's date of hire, or 1 year after his or her employment ends, whichever's later. And what is E-Verify? E-Verify is actually a free government system that allows you to check immigration status. It does not replace the I-9 reporting requirements or record retention requirements. It's voluntary, except most federal contractors and some contractors have to comply with it, and there are certain state laws that require you to use E-Verify. There are certain large employers that have, as a policy, determined that they're going to use E-Verify. And the recommendation I have for that is, if you do it for some workers or some types of workers, you do it for everybody, because you don't want to have a disparate impact claim that, well, you know, you only make the bus drivers, you only verify them through E-Verify, and nobody else. And Virginia requires state agency participation in E-Verify.